You went out for dinner. You had 2, 3, maybe 4 drinks over the course of the night. You felt totally fine. You weren't stumbling. You felt safe to drive. You didn't have to go far. And you certainly, absolutely did not feel drunk. But then, all of a sudden, the red and blue lights flash in your rearview mirror. Next thing you know, an officer is shining a flashlight in your eyes, making you walk a straight line, giving you commands, telling you to stand on one leg, to blow into a breathalyzer. Meanwhile, the busy cars are passing by, and you're on the side of the road wondering, who's going to see me? Is it going to be somebody I know? And at the end of this, after you've been told time and time that you failed, you're facing a DUI charge that threatens your driver's license, your job, and your freedom. My name is William Pernik. I've been a criminal defense attorney for 20 years, and I'm here to tell you DUI cases are not open and shut. These cases are based on opinion, flawed science, and, yes, police bias. And today, I'm going to give you the 5 battle-tested strategies that we as lawyers use every week in court to dismantle these cases and to fight back. And I'm going to conclude this video with a critical mindset shift that can help you turn this entire nightmare into a new beginning. Number 1, the gymnastics trap and field sobriety tests. This is the biggest lie people believe. When the officer asks you to step out of the car and they tell you to follow a pen with your eyes, to stand on one leg, to walk a straight line, they act like these commands are mandatory. But they're not. You see, in California, field sobriety tests, or FSTs, are completely voluntary, unless you're on probation or parole in order to comply with them. As a civilian, you have zero legal duty to do these tests. And here is the secret. These tests are not accurate. They're not objective. They're often entirely speculative and are designed to make you fail. They sometimes administer them on uneven ground. The officer may not be well trained to look for so-called clues of impairment that actually could be just signs of nervousness or poor balance. Even a sober person with bad knees or anxiety could fail these tests. And if you agree to do these tests, you're just generating evidence. Evidence that the cops are going to use against you in court to convict you. You see, that CHP officer, he's already decided to arrest you. The test is just something he's using to build his case. The right move would be to politely say, "Hey officer, I respectfully decline to participate in any field sobriety tests." Number 2, the breathalyzer trap. Now this is where 90% of people get confused and get convicted. There are actually not 1, but 2 types of breath tests, and the rules are completely different. The roadside, pass, or preliminary alcohol screening tests are the ones that are given on a little handheld device that they use on you before you are arrested. This particular test is voluntary. You can, and usually should, refuse it. It can be completely unreliable, and it can read high. This is in contrast to the actual chemical test, the one they give you at the station, the evidentiary one. That one you're required to take by law, implied consent in California. The officers will read you an admonition before the test, and it will tell you that you do not have the right to refuse or consult an attorney before you make the decision, and that if you don't, your license will be suspended for a year. So what's the strategy? The smart thing is to refuse things that you're not required to take, but once the cuffs are on, submit to the chemical test at the station. Remember the difference. Don't mix these up. The rising blood alcohol defense. Police officers assume that your alcohol level at the station is exactly the same as it was when you were driving. But in many cases, the science says otherwise. This is because alcohol takes time to absorb into your bloodstream. If you had your last drink right before you left the bar, that alcohol might still be sitting in your stomach while you were driving. You might have been, as a result, feeling perfectly fine at that moment when they pulled you over for expired registration tags. You may well have been under the legal limit. But by the time they're done with the roadside gymnastics, they take you to the station. Now it's been 45 minutes to an hour, and your levels have gone up. They've spiked. This exact phenomena is called the rising blood alcohol defense. And we, lawyers, use forensic toxicologists in court to show that while you tested over the limit later in time, you were actually under the limit while driving, which is the only time that matters. The 10-day rule. Most people think the court date is the deadline. Most people think that the court date is the only deadline. Wrong. The moment you are arrested for a DUI, the DMV starts a separate clock and a completely different administrative process. You have only 10 days from the day of your DUI arrest or citation to request a DMV hearing. If you miss that 10-day window, your license is going to get suspended automatically, and that piece of paper they give you is a temporary license that's only valid for 30 days from the day of issue. That's it. No trial, no hearing, no arguments, just gone. So you got to be smart. You got to talk to a lawyer, because one of the first things you do when you take your DUI case to an attorney is they're going to contact the DMV on your behalf. They're going to request a hearing. In turn, this is going to keep you driving while we fight your case. It's going to give us a chance to fight it at the DMV hearing and maybe even prevent the suspension. So don't just throw that pink sheet of paper in your glove box and forget about it. Actually read it. Be proactive. Do the right thing. The police reports. I read police reports every day, and they almost always look the same. Suspect had bloodshot, watery eyes. He had slurred speech and unsteady gait. Most of the times, it's a cut and paste job. It's a template. But then, when we start looking deeper, when we investigate, when we pull body cams, what do we see? Wow, my client is actually speaking clearly. No slurred speech. He's standing up straight, following directions. No unsteady gait. We use this to point the disconnect, to show to the jury that while the officer is trying to describe a stumbling drunk in his report, the video actually shows a nervous but steady human being. And that's the moment when the officer's credibility collapses. We try to use their own camera against them to show that these so-called symptoms of intoxication, they're just bias in disguise. Now, before I go, I want to say something to you, not only as a lawyer, but also as a person, a human being. I've now represented thousands of people in DUI cases. And for many of my clients, the arrest wasn't just a legal problem. For many of them, it was a wake-up call. It was the universe tapping them on the shoulder, saying, hey, watch it, slow down, pay attention. Something isn't right. Maybe you're going through a divorce. Maybe the stress at work is crushing you. Maybe you've been using alcohol to numb a pain that you haven't dealt with yet. And maybe this arrest, as terrible as it feels right now, is the sign that you need to make some changes. It's a sign that you need to do something in your life. At my firm, we don't just fight the charges, but we also try to help people understand the reasons that got them in trouble in the first place. It doesn't apply in every case, but when it does, it creates an opportunity for people to learn and to grow. And so what I want for you, if this is a case where you know you've done something wrong, that you have an unhealthy relationship with alcohol, this is the time to wake up, to connect with the resources, with counseling, treatment, support, so you can address the root cause of your behavior. This isn't only going to help your lawyer in court, and it does, because judges love to see proactive change. But more importantly, it's going to help you in life, and it's going to ensure that you never find yourself in this position again. I don't want the shame of this moment to define you. Let it refine you instead. In conclusion, if you or a loved one is facing a DUI, please remember, an arrest is not a conviction, and a mistake is not a life sentence. My name is William Pernik. I want you to stay safe, listen to the signs, and if you're in trouble, find a good lawyer and call them. A good lawyer can help you get your life back on the road and not just beat the charges or help you keep your license. Thank you for watching.